Well, let me add my good morning to those you've already received. And thank you for having me. This is the first time I've had the pleasure of addressing this group at this conference. And I must say, looking at the agenda, I know I've been missing a lot. This is a excellent quality agenda, and in addition to thanking you, I need to thank a few people who put that together and made this day possible. First of all, my good friend Jenny Chong. Trina Mullins, I know, worked on it also, and Russell Hewlin had a big part in it. I know I'm probably missing somebody. That's always the risk when you thank folks, but for all who did this, that's great. Before we get into three major Supreme Court cases that are pending and will be decided by, at the latest, the end of June, I thought it might be a good idea to chat with you a little bit about civil rights generally. For those that were here earlier and had a chance to watch the video about ODOT and the beginning of civil rights, you're familiar with the fact that we are now in our 50th year, 51st actually, of the Civil Rights Act of 1964. This also marks the 51st year of the United States Equal Employment Opportunity Commission. We were created by the Civil Rights Act of 1964 and went into business a year later. That's not unusual in the federal government. As somebody who works in civil rights, and a lot of us do, we frequently get criticized, and people will say, well, you know, I heard you speak or I heard you talking, and you said, gosh, how far we've come in 51 years. But then again, I also heard you say not too long ago, we've got a long way to go. And while those statements seem somewhat contradictory, they really aren't. We have come a long, long way in 51 years. I mean, it's hard to imagine, and for those of you who are under 40, maybe under 50, it's almost impossible to imagine. My son can't get a handle on it. He's in his 20s. But 51 years ago, it was perfectly legal in the United States, the greatest democracy in the world, in my opinion, to basically tell someone you weren't going to hire them because of their race or because of their gender, national origin, religion. Perfectly normal. It was also perfectly legal and normal, quite commonplace for employers that hired women to tell them that they were going to get half the wages that men got, even though they were doing the same work or maybe more work. The concept that women belonged at home raising the kids, and if they chose to work, it was just like icing on the cake, so they shouldn't get paid as much. So when you look at what we have in 2015, we have come a long, long way. Unfortunately, we haven't come far enough. There are still those times when those of us who work in civil rights will take a look at a case on the enforcement side that's particularly egregious, or maybe it's not particularly egregious, it's just repetitious of something we've seen over and over and over again recently. And we realize that we've still got a long way to go. How far we've come, there is a handout in your materials. It's not a slide, but it basically outlines the laws that we have on the federal side that will affect what you do as employers and employees. I encourage you to look at that as your time permits, but those are important things, and they mark milestones in both civil rights and equal opportunity. What's all that mean for you? Well, the only thing I can suggest to you is that your best and most useful resource is your human resources. And I encourage you to continue to be vigilant that you make your decisions based on the merit of those individuals, of those human beings, and not on a protected status. It's only in that way you're going to ensure you have the best functioning business, the best functioning operation, and at the same time meet the goal of making sure that we do in fact have equal opportunity for all in employment. Keep that in mind, if you will. We'll kind of move forward, and if I could get that first slide up. This is an area that I get asked about frequently, and I'm not going to spend a lot of time on it because we could spend all day. But basically, this is the 6 priorities, or this is the Commission's 6 priorities for enforcement for the 5-year strategic plan. And I'm not going to read them to you. You can read them yourself. I will obviously take questions on them. But that's where the Commission's focus is. The most important thing I can tell you is that's where our focus is, but that's not where our only emphasis is. We're again looking, as does the Attorney General's office under the Oklahoma state law preventing discrimination, as well as folks from the ODOT Civil Rights Division. We look at all areas where there could be infractions. But these are the strategic priorities for the Commission, and I just wanted to make you aware of those. It's another thing, too, when we talk about the Supreme Court cases very shortly, we think of enforcement and litigation. And while we are a civil law enforcement agency, as is the Attorney General's office who enforces state law, we're also an outreach organization. I firmly believe that sessions and programs such as this are the best way to make inroads, far superior to litigating a single case or even a class case involving a single business. This way we can reach, through outreach, large and wide audiences. And having said that, I will offer that the Commission does have an office, our district, in Oklahoma City, and we can provide training to you, whether that's at the regional seminar, technical assistance program seminar we call them, that Jenny mentioned earlier, or whether it's some individualized training a business or a group of businesses would want. All you have to do is give us a call. And it's 405-231-4911. We're in the government or the blue pages. Ask anybody, ask myself before I have to leave today. And we'll be glad to do that training. And again, I feel that reaches a far broader audience and does far more than we would ever hope to do with enforcement actions and litigation. They're a necessary part of what we do, but not the only thing that we do. And I encourage you to keep track of the outreach. Shifting gears a little bit, let's talk about these Supreme Court cases. It's unique that you get 3 cases involving employment discrimination, and specifically the EEOC, to the Supreme Court in the same year, but that's what we have. And these cases are landmark. They're going to change the scope of what EEOC does, and frankly change the meaning of the law, the interpretation of the law, for a long, long time, if in fact change is to come. Unfortunately, I've got to catch a flight back to St. Louis, and I have to go to Kansas City on the way to take care of some business in our Kansas City office, so I'm not going to be able to stay either to take your questions or for the rest of this great program. So I'm going to walk around as needed. I encourage you to ask questions as we go along, because I may not have much time after I'm done. The first slide, please. This case is one that will probably make a little more sense to you who haven't been to this conference before, but it's Young versus United Parcel Service. And I see that you're going to have some training later in the day on the ADA, that's the Americans with Disabilities Act, and you will learn that the the law governing disabilities requires reasonable accommodation. You will also learn under Title VII that religion requires reasonable accommodation. But none of the other laws do. None of the other protected statuses are you required to reasonably accommodate. Only disability and only religion. Young presents an interesting issue in that it may require reasonable accommodation based on gender for pregnant employees. In Young, United Parcel Service had a policy that really isn't unlike a lot of companies' policies, especially those in the transportation business. It granted accommodations and actually had make-work jobs for 3 classes of individuals. First, and the easiest understood, were those that were disabled under the Americans with Disabilities Act. And they accommodated because that's what the law says they have to do. Number 2, they accommodated individuals who were injured on the job. There's no law per se that says you have to do that, but from a business operational standpoint, it makes sense. I'm going to pay the person. I want him or her doing as much as they can if I have to pay them. So their policy allowed for accommodation and make-work jobs for individuals who were injured on the job. The third one is somewhat unique to the transportation industry and comes out of a collective bargaining agreement. And it's fairly common. You may even have one. And it basically says if a driver loses his or her CDL, we will accommodate them by finding them non-driving duties to do at their same wage. That's something that's negotiated with the Teamsters and the other unions that may be involved. It's not discriminatory on its face. It's a collective bargaining agreement. We agree to a lot of things in contracts. Well, Young said, but I'm pregnant and I need an accommodation. And they said, well, you weren't injured on the job, you're not disabled, and there was nothing about the pregnancy that would amount to a disability. A pregnancy that rises to the level of a disability does have to be accommodated, but that wasn't the case. And they said, you're pregnant, you can't lift, above 20 pounds, and our driver's got to lift 70 pounds. No dispute about that. And we're not going to accommodate you. And, you didn't lose your CDL, you can still drive. You just can't lift more than 20 pounds. So, sorry, we're going to have to let you go and not pay you. She'd exhausted her sick leave with in vitro fertilization, so she was basically out without pay. And they said, but you're a fine worker. Come back after you have the baby and we'll be glad to give you your job back. And Young said, this isn't right. You're accommodating all these other people. Supreme Court took the case, and they're going to decide whether the language in the Pregnancy Discrimination Act, especially or particularly the second clause that says that people who are pregnant will be treated the same in all respects, really means will they be treated the same in all respects. We'll see. I don't make predictions about what the Supreme Court does. Number one, if you wanted to bet money, you would bet against what I say because I'm usually wrong. And I've been wrong so much I'm not guessing anymore. It's going to be an interesting case, though, because if you really look at it, if they rule in favor of Young, it will create a whole new class, protected class, that is entitled to reasonable accommodation. We'll see. Best I can do is guesstimate that it's going to be a 5-4 decision with Justice Kennedy being the swing vote. Again, I could be wrong on that too. What's interesting also about the case is that although UPS is litigating it, they changed their policy on January 1st saying we're going to accommodate pregnant women. But it didn't moot the case because the issue is still ripe for decision. And frankly, if the court rules in UPS's favor, you wonder if they might change their policy back again. But it is what it is, and that's a case worth watching. The next one, if I could have up EEOC versus mock mining. This is pretty much of a procedural case, but has broad-ranging implications when we're putting on our enforcement and litigation hats. And that issue is whether courts can review the Commission's conciliation efforts. And the statute says, and I don't want to get too technical and try to teach a law school class here, but the Title VII and all of the other statutes, Age Discrimination and Employment Act, Americans with Disabilities Act, Genetic Information on Discrimination Act, and the EPA, all require that if we conduct an investigation of your industry or of your business, and we find cause, which we do about 5 to 7% of the time, we find that there was a violation of the law, then we can't just run to court and force you to, pay money. Before we go to court and seek relief, we've got to sit down with you and conciliate in good faith. We have to try to resolve it. That's a statutory requirement. Unfortunately, the statute doesn't say much about what we're supposed to do. And actually, it doesn't say anything. It just says we're supposed to conciliate, engage in conciliation. Doesn't say how long, doesn't say how many letters we're supposed to write, doesn't say how many phone calls we're supposed to make, doesn't say whether or how many conferences we're supposed to conduct with the employer that we allege and have found has violated the law. And in mock mining said, you guys sent us a letter and said you found us in violation, and you made a demand for millions of dollars and a lot of non-monetary relief, and it was sort of in take it or leave it tone. And we responded, we thought that was out of line, and you all sent us a conciliation failure letter. You sent us a letter that said, we've tried to conciliate, and we don't think we can conciliate it, so adios. Well, the district court agreed with mock mining, and they threw our case out. They said, EEOC, you didn't conciliate in good faith, and therefore you lose. More importantly, wasn't so much EEOC losing, it was everybody who we were seeking relief for. Keep in mind, when we litigate a case or when we investigate a case, we're not doing it for ourselves. Our duty is to investigate for folks that we think have been the victims of discrimination. And so when they said, get out of here, what they said was all of the people that were discriminated against that are entitled to relief don't get it because EEOC, you didn't conciliate in good faith. That's kind of harsh. Well, we went to the Seventh Circuit on appeal, and the Seventh Circuit said, we're going to go completely in the opposite direction, and we're going to overrule or find that the lower court was wrong. Yeah, the statute says EEOC is supposed to conciliate, but it doesn't say what that means. As I mentioned earlier, it doesn't say what EEOC is supposed to do. Doesn't say how many phone calls they're supposed to make, doesn't say how many conferences they're supposed to conduct, simply says they're supposed to conciliate. And if they say they conciliated in good faith, and they've decided they can't reach a resolution, then it is what it is. So there really isn't any judicial review of the conciliation effort. Well, mining obviously petitioned the court for certiorari. It was granted. The oral arguments have been had. Again, I can't make a guess, but we're going to know, I can tell you for sure, we're going to know one of three things, and that's going to be how far a court can look at our conciliation efforts. If they're like the district court and about 1/3 of the federal courts of appeals, they're going to say, yeah, we can look at it. We can look at your conciliation efforts, and we're going to scrutinize those conciliation efforts. And we, the court, are going to decide whether you did enough. Statute doesn't say how many calls you got to make. Statute doesn't define good faith, but the judiciary will decide that. That's option number one. Option number two is you go to the other extreme, as the Seventh Circuit Court of Appeals did, and you say, yeah, there's a duty to conciliate, but Congress wasn't clear about what that is, and there's no requirement in there beyond the duty to conciliate. So if EEOC investigates and files a lawsuit and says, we tried to conciliate it, that's good enough for us. That's the other extreme. The middle ground is, and I hate to do this, but I kind of think, or I kind of hope this is where it comes down, because I don't like either one of those extremes, quite frankly, and that's personal. I don't make policy. I kind of like the middle ground here, and that would be for the court to say, yeah, there's a duty to conciliate, and yeah, there is some degree of judicial review. But if we find that there wasn't adequate conciliation, rather than hurt all of the victims who've already been hurt by being the victims of discrimination, what we're going to do is make EEOC go back and conciliate again and do it right this time, rather than dismiss the case and dismiss all those victims, never again to have any day in court. Again, that would be far superior to just out and out dismissing everything. Again, though, I can't predict where it's going to go. I simply can't do that. You know, if you look at the statute, you could argue there really aren't any standards there, so it ought to be up to EEOC to decide. The counter argument to that is that if judicial review is going to be nullified by Congress, they have to do it in express terms. And that's why I don't think it's likely that that first extreme is going to happen. Again, the middle ground's preferable, at least in my opinion, than to dismissing all the claims. Third one, if we can. And this one you may know more about than the other two because it originated here in the good old state of Oklahoma. EEOC versus Abercrombie and Fitch. During my tenure with the EEOC, I sat a couple acting details, and one was to Oklahoma, in this Oklahoma City area office. And during that time, this case was being investigated, and we ultimately found there was a violation of the law. And the issues here are whether an employee, or in this particular case, an applicant for employment, has to make an explicit request for an accommodation on religious grounds before the employer is required to act on the request. The facts of this case, if you already know them, I won't belabor them, and you may well, because it happened in Tulsa. But the charging party, Ms. Ulof, applied, it was a Muslim, or is a Muslim, I should say, and she applied for a job at Abercrombie and Fitch, which has what they call the look, L-O-O-K, policy. And it's kind of best described as they want you to look East Coast and preppy. All right, that's what they want all their salespeople to do. Well, actually more than salespeople. And Ms. Ulof wore a hijab during her job interview. And they were very impressed with her during the job interview, but in discussing, when the interviewer was discussing privately with the manager or some division manager the fact that she wore a hijab, he said, well, that doesn't fit with our look policy, so don't hire her. And they didn't. Well, we said, hey, wait a minute. That's, you're not hiring somebody because they wore a hijab. I mean, at a minimum, you should have reasonably accommodated it. I mean, otherwise, she was quite impressive. And we won, actually, on summary judgment at the district court level. That was in Tulsa. That's highly unusual for any plaintiff, much less the EEOC, to win on a summary judgment. That means the evidence is so one-sided that the judge believes there's nothing really left but a question of law, and there's no need in convening a jury and having a jury trial. It is what it is. The law is what the law is. And they found in our favor. The Court of Appeals in Denver was sitting in Denver, the 10th Circuit, and there was a minor, what I considered to be a minor issue in the trial, and that was the fact that Ms. Ulof never specifically requested during her job interview an accommodation. But believe me, that was just a small part of the issues. I mean, really, their whole defense at trial hinged on this look policy. But that was an issue about whether or not she requested an accommodation. And the 10th Circuit said, she didn't explicitly request an accommodation. She wore a hijab, but she didn't tell them it was for religious reasons. How were they supposed to know? And so the 10th Circuit ruled against us, and we sought certiorari, and the court did grant it. The case was argued Wednesday, just a couple days ago. And again, no predictions. If I predict, remember, bet against me. You'll win a lot of money. But from most of the folks I've talked to who were at the oral argument, they say it really looked like at least 8 of the justices, pardon me, 7, were very favorable to EEOC's position. So we'll see. Justice Scalia apparently was not overwhelmed with our argument, and Justice Thomas didn't say, I don't believe, ask any questions at all, which is not unusual for Justice Thomas. That's simply the way he does oral argument. But we'll see what happens with that. It's kind of an interesting case. On the one hand, it's somewhat preposterous to say, well, somebody was sitting there with a hijab and you couldn't figure out that maybe they were doing it because they were Muslim. But I see the other side of it. What if it's something not quite as obvious as a hijab? What if it's something else? Are we putting the employer in the position of having to guess and ask a question like, are you wearing that because of your religion? That's, I can see that side of the argument. I guess the bigger question, I talked about this case at a program similar to this a few weeks ago, and an individual, well-respected attorney and somebody I knew when I was in law school very well, asked me the question and said, well, if they rule in EEOC's favor, then what's to stop that decision from applying to disability? And I thought to myself, you're right. You do have to accommodate disability just as you have to accommodate religion. And are we then putting an employer in the position of saying to somebody, I need to ask you because you don't have to explicitly tell me. And that kind of gets afoul of the commission's guidance on what's permissible during interviews. So it's a case I can easily get on the side of because I was supervise the investigation for all intents and purposes. So I'm very biased about it. But when I force myself, as I frequently have to do, I can certainly see the other side. So it's going to be interesting to see what happens with that case. As I said, that is all the time we're going to have between now and break. So are there any questions at all? Because again, I probably won't be able to stick around very long. And I'll carry the microphone around. Okay, great. Thank you. I'll still stay down here.
Thank you. I understand the regulations regarding religious accommodation, and I also understand that many of us do have labor contracts that call for seniority, absolute regulations about how people get to bid their shifts. And so if I hire someone who has a need to be off on Saturday, and his or her shift that they get to pick by seniority requires them to work on Saturday, how do you balance the two of those, one requirement and one contractual obligation?
Understood. And it's an excellent question. Keep in mind, the duty to reasonably accommodate requires that accommodation unless it would create an undue hardship. That's both for religion and disability. So, and the classic example of an undue hardship is when you have a collective bargaining agreement, also a policy that's followed rigorously, but definitely a collective bargaining agreement that says we're going to assign on a seniority basis the right to work or not work weekends. You're not required to violate that CBA. Okay. So you couldn't refuse to hire the individual if the individual told you they couldn't work on Saturdays. You couldn't make that decision, but you could say, if we hire you, you're going to have to work Saturdays because you're low on the seniority totem pole. And if they chose to work, then, and they didn't work, you would be in an undue hardship situation, and you know, whatever happens to people that don't come to work when they're scheduled to work, you would do.
Good,
so you would be on steady ground there. That collective bargaining agreement's classic undue hardship.
Okay.
Any others? I know I was about as clear as mud. Yeah, there's one back there.
Just as a matter of curiosity on the hijab case in Tulsa, is there any indication that the applicant went in specifically to test the Abercrombie and Fitch policies?
No evidence of that at all. She was legitimately interested in, she wanted to work.
Okay, thank you.
And literally, she fit the Abercrombie and Fitch bill except for the hijab. I guess that's a roundabout way of saying she looked preppy. Don't ask me about that look policy, because that still kind of freaks me out. It's funny, Abercrombie's been in a lot of trouble in a lot of places because of that. One I wasn't involved in, and our district wasn't involved in. But keep in mind, it's to portray this preppy look to the people that come in to buy stuff, and they applied it to somebody who was a warehouse worker. They said, well, you don't have the look. I mean, the guy's loading trucks, for God's sake. He's not selling anything. Go ahead.
Good morning, Judge.
Good morning.
Lamont Carter, DBESS Supportive Services. And my question is also a curiosity question about the first case with UPS. What were the make-work accommodations that they gave to the pregnant woman when...
They didn't give her any.
What were the new guidelines that UPS came out with?
I think they basically said they would accommodate individuals that were pregnant. Yeah, it would be some like, you know, take her out of the lifting requirement. It was a pretty strenuous lifting requirement for UPS drivers in the class she was in. It was one of those 70-pounders, and it was pretty much all the time you were lifting close to 70 pounds or 70 pounds. So it was a legit lifting restriction. But yeah, they would have put her in something that didn't require lifting that much. Yes, ma'am. Hold on a minute so everybody can hear you. Thanks.
Hello, yes. I was wondering your thoughts on the new legalization of marijuana in some of the states across the country and how that impacts the random drug testing, and that if you've heard anything or what your thoughts on that are.
I wouldn't touch that one with a 10-foot pole. You know, I don't know. I mean, really, I shouldn't even say this because I haven't even given it any thought. We don't have any guidance on it. But, you know, keep in mind, you know, terminating somebody for illegal drug use is perfectly legit. And specifically, the ADA, Americans with Disabilities Act, says people who are actively using drugs, illegal drugs, you can fire them. They don't have any accommodation coming. But now what do you do? Because in Colorado, it's not illegal anymore, but in, you know, Missouri it is. I don't know. I mean, it presents interesting questions. I think an employer, whether it's an illegal drug or not, can have a policy that says not on duty, and you can't be under the influence while on duty, just like they do with alcohol policies. And so I don't know that it's going to have a big effect, but I hate to say that because it's so new. But thanks for trying to get me to answer anyhow. That was a minute and a half non-answer. Anything else? No, that's typical. Don't stand between a group and their break. Well, again, look, thanks for inviting me. Again, you have a great agenda, and I commend you for coming, and I commend you for being here and doing this, and I encourage you to take advantage as much as you can. And remember, again, and I'm not lecturing you, but your biggest asset, no matter what you do, is your human resources. And you just can't go wrong by having the best qualified person do that job, irrespective of any of our little implicit biases, and I know we all have them. So enjoy your conference, and thank you very much. Thank you.